Welcome everyone once again to this episode of the Real Wealth Solutions podcast. My name is Darren Light, along with my co-host Greg Scully. We hope that everyone has enjoyed their Thanksgiving holidays. We're about to roll into the Christmas season. Today, we are very fortunate to be joined by our guest, Lindsey Hobbs, attorney who is also our legal counsel representative in all things multifamily. We're very excited to have her. And we're also very excited because we just learned this is her very first podcast. So everyone get ready. She's going to bring it. So Lindsey, thank you for your time. Thank you for joining us. If you don't mind, just give us maybe a little background on how you got to where you are in your line of work. And we'll just kind of go from there.
Sure. Well, I'm an East Tennessee girl. I was born and raised outside of Knoxville. Went to the University of Tennessee and got a couple of degrees there, but then went to the University of South Carolina and got my law degree. I graduated at a wonderful time in a horrible market and went down to Georgia and took a job doing commercial collections more than anything, but representing lenders and banks, and even did some FDIC representation about commercial properties down there in coastal Georgia and South Carolina. Spent about 7 years doing that before I came back up to Knoxville and got involved doing a lot of transactional work. So I do both litigation and transactional, all on the business side. The joke I tell people is I can't get you out of your marriage or jail, but I can do a lot of things with your business if you need it. So, and started a few years ago, had a deal come my way for an apartment complex, did a contract for it. It was a very specialized situation. It involved the rural development and limitations on the deal for that. And then had a few more apartment complexes come my way. And 5 years later, doing a lot of transactional work for multifamily housing and commercial properties. I recently became a senior associate attorney with Breeding Olinzock Carter Crippen, which is based out of Knoxville, and does a wide range of services through our firm here.
It's interesting that you've actually found a niche, from my perspective, in multifamily and I guess commercial, if you will, that you sort of touched on. We're just going to go ahead and dive into our list of questions for you. So what is your role specifically then in that realm? If we want to buy an apartment complex and we want to use you as our legal counsel, what's your specific role and what do you help us do, I guess?
So I do the contract end of things. You generally are going to have several different attorneys involved in a transaction. I represent either the buyer or the seller and help with the drafting of the purchase and sale agreement, negotiations. I was joking before we started, making sure that all the deadlines are on your calendar and making sure that deal gets from literally the beginning, the letter of intent, to the closing. And that's my job, is to make sure that your deal goes through in a way that you're happy with. You will also have title attorneys. So I'm not a title agent. I'm not a closing attorney. I just do the contract side of things. And I work very closely with several title attorneys in states throughout the country, because it will be state specific on the actual title documents and closing. You'll have an attorney usually representing the other side. If you don't have an attorney representing the other side, it makes my day a lot easier, but usually we get an attorney on the other side that's reading and redlining everything that I'm doing. And then you'll have a lender's attorney. You'll have a whole group of people that are involved, so that your email chain by the end of this is going to have probably 20 people. But I will represent one specific party. So if you all are buying something, my job is to make sure that you're getting it at the deal that you want and what you're happy with.
What are the limitations of the templates? Why can't I just go to LegalZoom, pay $14, crank something out, or have my commercial broker grab something off of the Tennessee, MLS docs? why aren't those good enough? Because that's the question I hear all the time. And I love having an attorney. And first question, what's the difference between an attorney and a lawyer?
I can tell you the very academic, there is no actual difference between an attorney and a lawyer, except that in Britain, if you have your law degree, you're a lawyer. If you are a practicing lawyer, you're called an attorney. And I know that I took a class at an Inn of Court in London while I was in law schools. And that's where I learned the difference. And I was like, oh, never heard that before. So
yeah, I thought it was maybe a difference between practicing law in front of a judge or practicing law behind a desk, that there was some kind of difference between where the activity took place. Okay. Tangent gone.
Yeah, no, we're completely interchangeable. What you'll usually see is the difference between a litigator, who's someone that goes to court, and a transactional attorney, who is someone that's mainly sitting behind a desk working on paperwork. So
okay, maybe that's what was driving me. But yeah, back to the I found this thing online. It's free. I just downloaded it into Adobe, and I can just change anything I want on it. What's wrong with that?
Well, first off, I cringe every single time I see one of those. If you're buying a house, that's 9 times out of 10, that template, like let's say you're just buying a house, that's fine. It's going to be almost the same thing every single time. Apartment complexes specifically, and commercial transactions in general, they're so nuanced. And there are things that I think the longest template I've ever seen was a 15-page commercial purchase and sale agreement template. And someone sent it to me, who will remain nameless, and said, hey, is this okay? And I said, that's fine, except it doesn't assign any leases to you. Did you want to have the leases to go with these apartments? There's so many things that you think seem like common sense that are going to be in these contracts that are not. And most people, it will be okay until it's not. And I've had a handful of times where people have come to me and they're upset because I have a contract. I'm supposed to buy this property. They're not selling it to me, or, they're supposed to buy the property, and it's completely unenforceable for various reasons. Is it too vague? Does it give them an out that they're using and that they have every right to use? Is it not actually requiring them to buy that specific property? It's everything from, when I get a deal, the first thing that I do is I look at that LOI and I pull up the property records and I will see who's the record owner of it. You have people that go under contract that are not the record owners of property because they have so many subsidiaries. They don't really think about, well, this person's signing as the seller. They may not own that property. You have a completely unenforceable contract. They can't sell something they don't own. And people just filling those things out quickly, or letting your broker, and no offense to brokers, but letting your broker just really want to get that deal on paper, you're going to miss those nuances. And that's really what's going to hurt you in the end. And there's a lot of things that my standard purchase and sale agreement, the shortest one that I do that I feel comfortable with, is about 25 pages. Long form, I've had them go up to 70 before. And it's everything from attaching the closing documents, the assignments of contracts, all of those things, your due diligence list. Those are things that you're not going to get on a form contract. There's things specific for apartments, like I said, assignments of leases, that's rent-ready provisions. Those are things you are not going to get on a form contract. And I have edited and tried to use form contracts if necessary, but honestly, you're going to end up putting about the same amount of time into fees to try to fix that form contract as you are to have a new one drafted from the start. One thing I'm going to put out there, and I've said this to a few people over the years, is that regardless if you're the buyer or seller, I recommend that everybody keep control of your professionals. I know it may seem like, oh, well, they want to use their attorney to draft something, and I'll just use that. You want someone who's working for you. If you two guys come to me and you're going to buy something, my entire job is to make sure that you get it and you get the deal that you want. You want to keep control of those professionals. And I've seen people that my recommendation is, oh, well, they want to pay the legal fees for it. Then you hire me and let's build in the legal fees as their expense that they have to pay at closing. You can negotiate for that, but having a title attorney who is on your side and an attorney who's on your side is just, you cannot miss the value in that for what's nominal given what you're about to spend or receive at a closing.
I will say from a single family historical perspective, personally, especially on the title side, man, efficiency. People lack efficiency. And I love your statement, control your professionals. And you're just being point blank about it. Hey, and there's nothing wrong with that statement. That's one thing that you can control. And I think as we've gotten into multifamily, we see how important it is. I mean, $5,000's nothing. I mean, in a multi-million-dollar grand scheme transaction or more, if it's a syndication, whatever the case may be. So, and I credit Greg for a lot of the details. That's a lot of his talent and things that he does and sort of specializes in to make sure that we're crossing the T's and dotting the I's. Not that I'm blasé about it, but I understand more and more now the importance of, what you just laid out.
Yeah. And like back to the cost thing, I hear people complaining about the cost. I'm like, man, if your financial engineering or projections are hinging on whether or not you can afford a $5,000 legal fee, you might just want to go back and review the fundamentals of this deal if you can't price in the cost of the acquisition in market rates. I mean, we price in, 10 grand, hoping that it comes in at 5. And if, it costs 10 grand, well, we've planned for it at least.
Well, and if there's no problem with it. And I mean, I will say personally, so I bill on an hourly rate and that works just fine with me. I think you probably see on closing statements, like lenders councils usually bill a percentage of the loan. So you'll see a very large flat fee number for them. But I bill hourly, so you're paying for what the work I'm actually doing. And if it's straightforward, if it goes from A to B and it's just easy, we're fine. But when you start getting into, even with doing amendments or problems pop up with title objections and all of those things that I help with from beginning to end, I still don't think I have ever seen a closing statement where my fees were as large as a lender's attorney.
Mm-hmm. Yeah, right. And I think some of people's objections are the complexity of it, that it just seems to get so complex that maybe some people are afraid to lose the understanding of it. I don't necessarily look at contracts as being more complex. I think it actually adds more specificity, and that's not the right word, but the specifics is what I like about it, because it gets the difference between, are we talking about business days or work days? So that goes back to like the timeline. It's like, this says 7 days, just defining what those days actually mean so that everybody is working from the same base level of knowledge and there's no assumptions being made. That adds a lot of language, but it also adds a lot of clarity. And, with a little bit of practice, and I read every contract. I still do. It's not fun. Yeah.
You do.
And but you do that a few times, you start to pick up on the complexity side of it, because we're going to be doing the same things over and over. So there is going to be a lot of repetition in these contracts, and it doesn't take a whole lot of time to get familiar enough with them so that you can speak to Lindsey or whoever your attorney is and be able to communicate, because you're so busy doing so many other things when you're closing, property inspections, due diligence, lease audits, things like that. I don't have the capacity to try and play a part-time lawyer at the same time.
And you're echoing, Greg, what Lindsey mentioned earlier, is that nothing's a problem until it is.
Mm-hmm.
That's why you have all this stuff in there.
And I will tell you one thing that I have recently seen a lot of, that this goes back to the form contract situation, because you don't generally have this. Most of these deals are as is purchases. So the only thing that you have to go back on are the representations and warranties that are going to be in your contract. Most form contracts are not going to have any representation and warranties. I think mine's like 3 pages long, because your only recourse is what they warranted to you when you went into contract with them. So, oh, they didn't tell you that there was hazardous waste buried underneath there, and they actually knew that. I mean, that's something that you would think that, oh, well, obviously they should have told us that. Nope, you signed an as-is deal. So that's your gold standard on your contracts, of things like that people don't really think of. But I'm thinking of, you buy a property, guys, if you're calling me 6 months later because there's a problem, I want it to be a problem that I foresaw might happen, and to know that you either have recourse or you don't have recourse, and I told you weren't going to have recourse. And so that's a big thing lately that I've seen, is a lot of these sort of boilerplate off the internet contracts don't really have the solid representations and warranties that are specific to multifamily properties as well, that you would want to see.
And that's one of those things that gets by people. And this is one of my notes to talk about it. What are the other things that get by people? We already talked about deadlines. And I think that's very true. It seems like it should be a very easy thing just to throw into your calendar. And maybe I just don't execute on that as well as I should. But there are some very time sensitive things that happen within a contract that at worst, you're just at breach. You miss a deadline, you can be breached, and your earnest money deposit can be at risk of forfeiture. So any others besides, and that's what you're very helpful with, and I think most people are, is, you get into a contract, you send out a list of dates, and like, this is your date schedule.
I send a list of dates, and I like to send reminders. So you know what, Greg, you just continue relying on me to send you stuff, and that will work fine for both of us. So you don't need to put that on your calendar yet. No, the dates, the representations and warranties, the assignments, that's a big one that I've seen. I cannot tell you the number of times that I've seen a form contract that doesn't assign leases, or personal property, intangible personal and tangible personal property that goes along with the apartment complex. There are a laundry list of things that are the first things I identify that you're buying in one of my contracts you will never see in one of the template boilerplate contracts. So that gets by. Trying to think what else.
Does that go back to like the bill of sale type thing in the contract where, and I've heard this, where people buy an apartment complex, there might be a leasing office or something. They'll go on the day of sale and like all the computers will be on.
Yep.
Because it was never specified in the contract that those, is that just real property? No, that's not real property. That's personal.
That's called tangible personal property. And then you have intangible personal property. Things like the name of an apartment complex. You can buy that. You're buying that if you're using one of my contracts. Mm-hmm. The other big thing is, and this you will see sometimes, there's something called developer's rights. So if you're actually buying the complex or the property or whatever it is, if you're buying it from the person that built it, they may have special legal rights depending on the state because they're the builder. And they can assign those in a contract to the next person. And that gives you a higher amount of authority when you're moving forward. And so that's a big thing of making sure that that gets assigned, and that's part of it as well. So my contracts start with, here's our legal property. Here's our tangible personal property, which is office furniture, computers, anything such as that. Here's our intangible, which are all of these things, easements, anything else that they actually own that assists in running the apartment complex or running the property, you then want that assigned to you as well.
Yeah, and that can also include things like websites, social media stuff,
advertising.
Logos.
trademarks, logo. Yeah.
Have you found, along your journey of doing this sort of specialization, if you will, that each contract, each year that goes by, you're like, oh, I've not been addressing this and I need to be addressing this moving forward? Or I know, I guess, gosh, is because you've been doing this, you have everything addressed, at least in your mind at this point, that could go wrong? I know that's a very loaded question, but do you think that? I'm trying to get inside an attorney's head, I guess. I don't know.
There are 2 times that I recall specifically that I was like, well, now I'm adding this to my contract moving forward. And both of those times are situations, one of them's COVID related.
Oh, wow.
How do you close on a contract date if the Kentucky registrar's office is closed because of COVID?
It sounds really familiar because you helped me through this in March. There was these very real possibilities that dates were not going to be hit through no fault of any signing party to the contract.
Yes. How do you, yes. So if the government, and the other one was literally, it goes back to, I did the deal that involved rural development. We had a government shutdown. I don't know if everybody recalls that. We had a government shutdown. So when your closing date was 3 days after the government shutdown, how do you address that? And there are contract provisions and there are equitable provisions. There are equitable things that you can do in those situations. So it's not a lost cause, but it's also certainly something that now I look at and go, okay, especially in the time of COVID, you want to go ahead and foresee that. So I learn things all the time where I'm like, well, that's good. I should probably put that in there. I'm trying to think a specific assignments of or indemnifications. That was a big one. Tenant sued a new owner for something that happened under the old owner. Yes, what the language that was in there was sufficient enough to have insurance indemnification for the new owner, but there was some kind of back and forth about what exactly was going to be covered. So now I have really good language about that. And it was funny because the next deal I did after that, I had an attorney who, grumbled about it. He goes, I've never seen anything like this in a contract. I said, no. I said, but I just had someone get sued. So now it's going to be in my contract. And I enjoy, I've been practicing law over a decade. I've been doing these contracts specifically about 5 years now. I do probably several dozen a year. I enjoy talking to people that want to argue with me, or other attorneys that want to argue with me about their basis is I've been practicing law 30 years and I've never seen this before. Well, my basis is I just saw this. So now I'm going to have it in my contract because it's going to protect my client. And it really should make no difference. I mean, if you're the old owner and you're getting sued, don't you think your insurance company should cover the new owner as well for something that happened while you own the property? So that's something that popped up, and I specifically remember because the next contract where I put it in there, I actually had someone object to it, and we kept it in, and it's been in every contract since.
Yeah, and while you're talking about that, it dawned on me, another good reason to have your own counsel is because you don't know the complexity or the level of knowledge or business acumen of your buyer or seller, depend upon which side of the transaction. If it's me and Darren, first of all, I would still use an attorney, but especially with Darren.
Right.
But it may seem like, hey, we're on the same level, we'll get together just well. You might get into a contract with somebody far more sophisticated than you in terms of how they think a transaction would look. And if you're trying to do that by yourselves, I would fear for myself that it would go far beyond the level of knowledge that I would be able to handle, and be overwhelmed by the sophistication that some people might bring to a transaction.
And I will say that I don't know if I should say this on your podcast, but when I have a client come to me and say, hey, they don't have an attorney on the other side and we're just going to split your fees, could you just draft this contract? I promise you that contract is going to be a lot more favorable to my clients than if they say, hey, there's, an attorney on the other side, and they're going to review it. To the extent of, I think I've actually gotten some contracts through that were not as is purchases, which means they're going to represent and warrant absolutely everything about that property, regardless of if they knew it or not. So, I mean, I hate to say that I'm taking advantage, but I represent one party. I would recommend that everybody get an attorney. And if I'm taken, you can go find another attorney that specializes in this.
Mm-hmm.
And
yeah, right.
I will tell you, don't just go with any attorney too. You need someone who at least does commercial property transactions. Because I've even reviewed attorneys' contracts where I have raised an eyebrow about, some of this is too vague to be enforceable. So
that's actually one of our topics to talk about is how do you engage, for what we're doing? How do you vet? How do you engage and find that next person or an attorney to do what we want to do?
So, and y'all have been great to me. I am happy to talk to anybody that's just getting into this and wanting to know about using an attorney, in hopes that even if they don't have a deal coming 6 months, 12 months down the road, but maybe they'll think about me because I've talked with them about things to consider on the front end. Really looking for, I mean, if it's your cousin Jerry, who's an attorney that also helped you get out of your parking tickets, maybe not who you want to be using on a multi-million-dollar commercial purchase and sale agreement. You want to know what experience that they have in some sort of transaction. I get involved usually at the point of an LOI. Most of the time bless y'all, you send me an email that says, here's our LOI, we need it to be under contract in 3 days. And I will tell you, that is my number one thing. I try to be as responsive as possible and work on the deadline, because you need an attorney that's going to turn it around and get you what you need as quickly as possible. Because it may take me 2 days or 3 days to draft it, to get it, sit down and get it done. But I then have to send it to you, see if there's any questions. Then it goes to the other side. Then they send it back. So you're probably not going to get it under contract in 3 days, but you need to have that contract. So you need someone that's going to be responsive as well. But it's LOI to closing is pretty much where my time frame is. I've had a few people that have come to me where they've had an LOI and then they won't go under contract. LOIs are generally not enforceable. That's why you try to get them to sign a contract as quickly as possible. So
I know that we've sent.
Well, let's go ahead, Darren.
No, I was just going to mention that I know we've sent numerous people your way just because we do love working with you and have firsthand experience of how great you are at what you do and help us and add value. And so we've sent numerous people your way. I think just personally, and maybe you can speak to this, one of the best forms of credibility is just another person's recommendation that, yeah, we've done 2 or 3 contracts with Lindsey and, this is what she provides. And just a name drop is huge for me if I trust that other person.
Yeah. And I've been really lucky that I know that there's a pretty big community out there that I've gotten involved with. And I don't disclose who my clients are, but I've been lucky to have a few of them, I guess, give me some shout outs and refer people to me in that community. So and that's been great. And, I enjoy working with everyone because I want everyone to know that I'm going to have the same level of professionalism and care in what I'm doing on each transaction. And I understand what it takes. I understand that, if on Friday I'm given an LOI that needs to be under contract by Monday, guess what? My weekend is finishing a contract and sending it and turning it around because that's what you guys need. I like to think that my job is to make you not have to worry about some things. My job is to worry about the legal side of it so that you can look, because due diligence, I know the list of materials, I know some problems that come up. You all are out there running the numbers and figuring out, is this a good property? I'm going to say Greg is about the best in the business that I've dealt with in saying that, hey, this is or is not a good deal. And sometimes I do have clients where I want to be like, are you sure that you're, moving forward with this? But they do it. But Greg has been great at assessing the deal and seeing if it's a good deal. And so he needs to focus on that. I need to worry about your deadlines, what documents are being done, when it's closing, and making sure that that's taken care of for you.
Yeah, I'm fortunate that he's my partner, so I appreciate you echoing that. And I also appreciate you in regards to everything you do, but the fact that you communicate one-on-one with other parties' legal counsel takes so much off of us and all the in between, just adding room for error with another cook in the fire there. So that's great that you handle that portion as well.
Yeah, I mean, well, I was just to say, like, every deal that we've had, it's gotten to the point where I've just said, Lindsey, can you just talk to these people? I mean, or you've offered. It's just like, I don't know what the hell's going on anymore. Can you figure it out and get back to us? Because
that's a level of service.
It gets down, they redline, and now they're talking about,
I think that's a level of, I think that's a distinguished level of service. I can guarantee you that not every attorney is going to do that. They're just not, because they're sitting there, they've been practicing law for 30 years, right? Whatever the case may be. So I appreciate that.
Well, and I think there can be a tendency for people to eventually just take the easy out. You get beat down by going through this process and everything, and then finally you're just like, fine, whatever, let's just sign it. And that can be, that might work until it doesn't work. But it's nice to have somebody, third party. Yes, they're on your team, they're getting paid, they're compensated, but they're not an investor. They're trying to look out for your best interest. Somebody just completely keep you in check. And then, like, the other thing I was just thinking of with, why use a real estate attorney instead of your cousin Jerry, who's in family practice? I always try and change domains. So put in the domain of medicine. I'm going to go to my general practitioner for bumps and bruises and a general cold. But once it gets into something more severe or more specialized, you have to go to a different practitioner, or you may not get the level of service or the results that you need. So
and
that just,
I will say that my involvement on the contract, on the redlining, it depends a lot on who the client is I'm working with. How many times have I worked with them? I have several clients that over the years, I've gotten to the point I can say, here's their red line. Here's what they came back with. I'm going to give it to you. First off, you're going to have every version of everything, because if you're Greg, you really want to read all of it. A lot of people don't, but I'll say this is their red line version. Most of this looks reasonable. Here's 4 points though that I think we need to talk about. What do you think about X, Y, and Z? I changed this to this. Are you okay with that? And specifically asking about that. And I have clients that I feel like I have a good enough relationship with that they're going to say, okay, you're saying that these 5 changes are reasonable. These 4 changes are not. We're just going to focus on these 4. Because especially when there's an attorney on the other side, you do have to look at it like, what is reasonable in this situation? Like, I mean, you can't, go barnstorming and just say, I want it all and I want it my way. That's not really how a transaction works. I had a mentor once upon a time tell me that in transactional law, and I love it because litigation is tiring, but in transactional law, we are all trying to get to the same point. You want to buy something, you want to sell something. We just need to make that happen, that everybody's happy. And sometimes that's compromise. So I'm going to tell you to compromise on some things, and some things I'm going to say, absolutely do not agree to this. And that's the big thing, is I will tell you, and I will tell you in writing if there's something that you absolutely should not agree to.
Hey, it's Greg from Real Wealth Solutions. If you'd like to know more about our passive income opportunities, jump onto realwealth.solutions and hit that schedule a call button. We're always happy to talk about our multifamily and flip projects and to answer any questions you may have. Again, that's realwealth.solutions. We look forward to hearing from you. And now, back to the podcast. Let's go back to like engaging with an attorney if you haven't done it before. Would your preference be engaged at the LOI stage even before like I submit an LOI? Would you prefer that I'm like, hey, Lindsey, we really want to offer on this. Here's the LOI that we're going to kick out to them. They're not binding, but I know it does set up the PSA in a lot of ways.
And it's, with you guys, it's one thing because we've worked together several times. Obviously, I'm not going to do any work until you have an LOI or you know the terms of the deal, because there's no point in me starting and running up fees for you if you're not even sure you're going to get to the LOI point or get your offer accepted. Someone that's completely new, I would love to at least talk with them before they get to that point so that they understand kind of the timeline. And I've done this with a few people. Like I'll do a call, I'll do a video conference, and I'll say, this is what you're looking at, because it's a little harder when you're learning how to work with someone new to then have an LOI that needs to be under contract in 3 days, because you're explaining new things like that. If you want to give me a heads up that you've got something coming before it needs to be under contract that day, I'd appreciate it, but it's not a deal breaker for me, because again, I understand the time sensitivity of what you all are doing.
Yeah, and it goes both ways, because I mean, we also want to make sure that you're available.
Yeah.
I mean, for that reason alone, it's good to check in and say, hey, we're going to sign this with an executed LOI. We'd like to have the PSA draft in 5 days.
Yeah.
Does that work for you? And if it doesn't, you can be like, no, I'm going to blah, blah, blah. Can you make it 7 business days? I'm like, yeah, we can. Sure. Why not?
I want to say that the last deal that I did, a contract for you guys, I was driving across the country and still doing a contract in a camper at night for my husband's 40th vacation.
You read my mind. I was just about to make that blurb. So
yeah,
audience value.
Yeah. Well,
yeah. And then we didn't buy it.
Well, but I do remember that there was at one point my husband and I drove across the country to Yellowstone, and we get to the campground, and we were the closest campground to the entry of Yellowstone, and there was no internet. And I had no idea there was not going to be internet. And we were 3 days in the middle of a week. I had your contract going on. I had some other things going on. And at one point I drove 30 minutes to a Walmart parking lot to hotspot off of my phone so that I could get things done and things sent out before I could go back into the land of no connectivity. So luckily I have a wonderful husband who's very supportive of these things.
I picture the movie RV with Robin Williams. If you've never seen it.
It was not. We have a little tow behind camper, but we drove it across the country and back.
Yeah.
So, yeah.
And hey, great that you're able to do that, right?
Yes.
Work with flexibility and be with your family. And I love it. Today's times, yeah.
Technology is a great thing. And I mean, I think you have the ready availability of your attorney at all times. And that's one thing. The firm that I'm with is great, because if it's not me, I've got associates here that help. We've got law clerks. Like, there's always people here that can pick up if necessary, but that's really also what you're looking for, is you need an attorney that is going to understand what your needs are in the deal and making sure that it's on your schedule.
Do you also do like LLC formation and stuff?
I do LLCs. I do series LLCs, which apparently has become a favorite among your crowd. It's the new
Just a new thing to do.
Apparently, and I'm perplexed by it.
And let's form a fund too. Let's do that.
That's the other thing.
And I'm gonna make a shameless plug here. I have joined a firm that can do I don't do syndications, but we have a partner here that does securities registrations and can do syndications as well and do those documents. So, and that was a big thing when I joined here, was talking. I said, well, I'm really looking for someone that can do the security side of things, and they're like, we have someone here that can do it.
There is no way you're going to get through a syndication without having attorneys. That is just ridiculous. We're in one right now, and it's just the amount of legal from the lending side, at least for us, an agency debt specifically, is just amazing.
Yes.
The back and forth.
Real quick, since you brought it up, if you don't mind, on series LLCs, is it your belief that most people are using them now simply for simplicity, for forming additional ones, the parent-child relationship, and or due to it's supposed to be a cost savings for each one you form after the parent one? Is that basically the gist? I mean, I know how they work, but
I feel like
your take?
Cost savings, but I also feel like using a series LLC as a cost saving is almost like using a form contract, because I will tell you, it's my experience, not all title companies will let an unregistered child LLC buy property. Registered property. So I warn people, listen, it's fine. I can set up anything. We can certainly do this, but you need to make sure that whatever purpose you're using it for is going to be something that you can actually use it for, because you can't, I mean, if you can't get title insurance, you're not going to get a loan. And think about how many times a lender's asking you for a certificate of good standing. Well, you don't have that for a child LLC. You only have that for the parent. Are they going to just accept that the parent's in good standing and you have some documents? So it is interesting. I know that it's a new thing. I have some property investing clients that do residential property, and they use it, and that works really well for them. On the commercial side of it, I warn people, like, I'll set up whatever LLC. I can do the operating agreements. It is very specific for the operating agreements on what needs to be in there to make it a series LLC. So that's something to keep in mind. But I feel like somewhere this has become the trend to do, and I'm not entirely sure how it's going to work out in the long run.
Yeah, I don't see it being of benefit to us in the multifamily space. I knew about it being in the single family space a couple of years ago, and when I had looked into it. Even my local lawyer that I've used mostly for personal stuff, Clinton, excuse me, I probably shouldn't have said that, but anyway, 30 years in law, never heard of one. So never heard of a series LLC.
Is that your cousin Jerry and Clinton?
Yeah, that's my cousin Jerry, right? And he gets me out of all my speeding tickets. So
I will tell you,
I appreciate your feedback on that.
I had not heard of a series LLC prior to, so the two other states I'm licensed in, Georgia and South Carolina. Georgia, I think to my knowledge, doesn't even have a series LLC statute. So that's the other thing. You have some states that don't even recognize them. And then I came here and someone asked about it. And at that point, I was speaking with one of my employers, and he was like, nobody does that anymore. Apparently, there used to be some really good tax benefits in the state of Tennessee, but that are no longer there. And so people weren't generally doing it, but it's been a big thing lately is that people want to do the series. So it really just depends on what you're doing it for.
Right. Okay.
Yeah, can we talk about the LLC formation, and do I need a Wyoming LLC or a New Hampshire LLC? And people are setting up these LLCs in different states. I've never done it. I always thought it just reverted back to you're going to be litigated under the state statutes of whatever state you're operating in, and where your LLC is formed has less significance than I think people are putting that emphasis on. So correct me if I'm wrong. I don't know. I've always just like, I'm in Tennessee. I'm going to do an LLC here?
Usually you will have to do an LLC wherever the property is located. So I've set them up in Michigan, Kentucky. And I will tell you, so I'm licensed in 3 states. I do contracts in any states. I don't do closings. You have to have an in-state title attorney that does your title work and your closing, that knows that. And usually your title attorney, like I work with Mary Helen Story, who's with Signature Title here in Knoxville. And she and I work really closely together because she doesn't do the contract side of things. I work with an attorney named Rebel Lee out of Kentucky, who's a great title attorney and has been just an asset for me to have. And she does a lot of deals, I think, within your community as well.
By the way, that person helped out my title friend immensely. You sent that name and contact info months ago and was just awesome. Just
Rebel's amazing. And she's like me. Like I send her an email that's like, I need something right now, and she'll get right on it. And she helps in every way that she can. So
that's great.
I have only done LLCs in other states where properties have not been, because usually an accountant has told someone to do that. Legally, there's no basis for it. Usually there's going to be some financial benefit that an accountant has figured out, someone that can do better math than I. And if that's what they've been told by an accountant, I'm not an accountant. I cannot tell them differently. Even if you do that, you're going to have to register it in the state where the property is located to do business. So then you're going to be paying 2 Secretary of States for having the origination state and then registered to do business. And back almost similar to the series LLC, you need to check with your lender and your title company that having a foreign LLC, which is what it's called, just registered to do business, is going to be acceptable for closing.
Okay.
Lenders are very picky.
So it's more of a tax strategy than it is a protection strategy.
Yeah.
What
Legal
saying?
protections.
I found this on the web.
Apparently we set off Siri. Legal protections are basically going to be the same. And I mean, maybe Delaware has better protections, but I don't know specifically about Delaware. Usually when I'm setting them up where the company is actually doing business.
So if you have a Wyoming LLC, for example, and it's registered in Tennessee to do business in Tennessee, are you actually, could that tax savings cancel it out? It's maybe because you end up paying 2 states, maybe when it comes tax time.
Probably
for like F&E,
yeah,
like F&E tax or something like that.
For F&E, for your registration, and I don't know what the tax savings are going to be. I will tell you, this is something I haven't seen in a while, but Tennessee has something called the obligated member entity. You ever heard?
Yes.
So you can, depending on what your situation is, you can choose to have personal liability for an LLC. You're giving up the liability protection and you're exempt from all of your F&E. So looking at it, I've had accountants that have said, you can insure over the liability for X amount of dollars and it's going to save you Y. So there are some accountants that do that as well. But I've never figured out why having I've never seen a Wyoming LLC. That I don't think. No, maybe I have. Colorado. I had Colorado. And you can, if you have an LLC set up in a separate state. I just went through this with another one. We domesticated it here and changed it from a foreign LLC to an actual domesticated Tennessee LLC so that they don't have to deal with the other state anymore.
Oh, okay.
Yeah, relatively easy too.
Here's one other benefit that I remember of having an attorney, and this was you. When we had investors, so we're forming an LLC, we have an OA, and there's other people contributing. Some of those contributing entities were LLCs, and you were very helpful in making sure that those LLCs were doing their resolutions, giving themselves permission to invest in this new LLC. And I mean, that's something I never would have thought about asking people to do, or, and quite honestly, I don't even know exactly what you did, but I was like, oh, Lindsay's making sure these people investing in LLCs are having their house cleaning for their own LLC, giving them permission. So that's, you're protecting this new LLC by making sure these other LLCs are operating the way they should. Because once you have an LLC or a corporation, you're supposed to do your resolutions and this and that and unanimous consents. And I think a lot of the right way to operate under an LLC or corporation kind of gets put to the side once you're up and going for many of the provisions. And a lot of it ends up being done retroactively.
And you have a lot of people that do basically their personal LLCs that are going to own the interest in the companies that are owning the properties. And they're doing that for liability reasons, tax reasons, or it's them and two of their cousins. And so you all have an interest in that. That's how they're investing. And it's great. But if you're not paying attention to that formality that this person's allowed to sign, this is still an active LLC. This LLC is not been administratively dissolved by the state, then the liability is completely gone. And you also, or excuse me, the liability protection is completely gone. And then you also have the issue of, well, your lender on that main deal that you're working on is now all of a sudden concerned because one of your investors has a defunct LLC or, potentially has individuals involved rather than an LLC. And now we've got to go and run our background checks on these three people. So it becomes kind of a mess. The bigger the investor, like the bigger the number of the investors, I try to get those as far in advance as possible. It usually ends up right before closing that we're kind of getting that resolution done. But usually your lenders are going to want to see that too. So, And I'll say, talking about forming LLCs, I get the question a lot on when to form in a deal. I can form an LLC today. If you all decided that you wanted an LLC like registered with the state, I can do that quickly. That's not an issue. Operating agreements take a little longer, and where you have investors, you have to have an operating agreement. But I would not do that. I would not form anything until you're outside of your due diligence. I'd wait till the 30 days between due diligence and closing, or 60 days or whatever, because then you know that you're pretty much going to closing and you will spend the money then to get your LLC set up. So if you talk about cost saving, don't rush out and pay to set up your LLC first before you know that your deal is going to be basically closing, and that way you're saving that money.
Yeah, that's a good point. I mean, the cost savings, I have no problems saving money, but a lot of times it's just a matter of doing things in the right order. That's how you save money. I mean, you don't incur a cost until you know you're going to need it. But go ahead and incur the cost so that you're not like being litigated at some point and don't have a leg to stand on, because it's going to cost you a whole lot more than the initial price of that contract. So
if you have to do an action for specific performance, you are probably looking at $25,000 in legal fees as a baseline. So, if you're having to sue someone to enforce your contract, I mean, that's expensive, and you want to make sure you're in the best position to do that.
Right. So, all right. Well, we're about an hour in. I don't want to take up too much of your time because I'm sure you got work to do.
Yeah. Well, how'd I do for my first podcast?
I think you did great. No, awesome. This is super helpful. It's an important subject. I think a lot of people
gloss over it
basically.
And I'll tell you again, talking about the cost saving, I try to keep my fees as reasonable as possible because my work comes from you all being happy and coming back. That's why I want to help you. I want to make sure that you're happy, that you're getting the deal that you want. And I'm being reasonable about it as well. So that's selling my service right there, is that, My job is to get your deal done. And if I'm trying to gouge people on fees, there's no point in that. But if you're looking at a multi-million-dollar deal and you're trying to save a couple of $1,000s in attorney's fees up front, it's a lot more expensive when it goes wrong. So a little on the front end is going to be a lot when it goes wrong.
Mm-hmm. Yeah,
Great advice.
just price it in. That's what I keep
I will
pounding
also,
on the table.
I will also say my disclaimer is that you can't prevent anyone from getting sued. Just remember that as well.
Mm-hmm. Right. So.
So,
All right. Well, thank you, Lindsey. I'll go ahead and wrap it up, Darren. We want to thank you for joining us again on the Real Wealth Solutions podcast. If you know somebody that would benefit from this conversation with Lindsey, go ahead and share with them. We appreciate the exposure. And if you want to know more about us, you can find us and our contact information at realwealth.solutions. That is it for now. Darren,
How can they
you
find
got
Lindsey?
something? Oh
How
yeah,
can they find
Lindsey.
Lindsey?
How do we get a hold of you? We'll drop a bunch of stuff in our show notes too.
Breeding Olinzock Carter Crippen PC out of Knoxville. It's really long. Lindsey at breedinglaw.com. 865-670-8535. You become a client, you get my personal cell phone number too, but I'm not giving that out on your podcast.
No problem.
All right. Right on. Appreciate it. And we'll see you all on the next episode.
Bye.